Policy Studies Department and had the privilege of working with Martha McCarthy for several years before she moved to California. So first on our panel is Martha McCarthy. Gary Crow already gave you some of her background. In fact, she was a professor at IU for over 30 years, and he went through her list of accomplishments. I mean, how many articles are we up to now? 300, 400. Prolific writer, author of many, many textbooks and leading school legal articles, presentations all over the world. We're just so pleased to have her back and to have this institute named after someone who was so influential, not only at Indiana University, but the state of Indiana and country and in the world. So thank you, Martha. Next we have Lisa Tanzel, and she has been coming to these conferences for a few years now and on several different panels, and we are thrilled to have her back. Lisa is an attorney with the Indiana School Boards Association, and like many of you, we rely on her at IU for her expertise in special education law, bullying and harassment, all sorts of other topics that she has such a great area of expertise in. So we're thrilled to have Lisa back to get her perspective. And next we have Stephen Harper. Stephen Harper is an attorney with IU General Counsel's office. He taught school law with Janet and I for several years before he left to become IU's attorney. He's a former high school teacher. He taught at Bloomington High School North with English, I believe, right? High school English. And then we recruited him to come work in the School of Ed while he was a law student and finishing up law school. So we are really happy to have the three of them here. I just want to make one quick plug. You should download the app. It's on the back of your program. And we would love for you to tweet at hashtag IUEdLaw2016. You can tweet about all the great things you're going to hear from our three panelists. And if you'd like to follow someone who's tweeting about the conference, you can follow IU Ed Leaders. So I think we're ready to get started. This panel welcomes interruptions. They would love for you to, as they're speaking, if you have any questions, raise your hand, and you can chime in with different questions, and they're happy to answer. Steven said we're going to give all the hard ones to Martha, so. All right, so lots of new developments in the last year in this area. So let's start off with a question on a very recent development, or fairly recent development. I'm wondering, I'm going to start off with Stephen. Is there recent guidance from the U.S. Department of Education regarding K-12 Title IX compliance with respect to school districts' responses to issues of harassment and/or sexual misconduct?
Yeah, thanks, Suzanne. And we heard quite a bit from the last panel about the recent OCR guidance regarding transgender students, so I'll skip over that a little bit, and I know you got a chance to hear about that later. Certainly you've seen in the news, and it's been hugely under the spotlight for colleges and universities, is the world of sexual assault, and what are universities and colleges doing to prevent sexual assault, sexual misconduct on campuses. And I think it's flown a little bit under the radar in the K-12 realm, but I think if we look at the statistics and also kind of anecdotes out there, there's no doubt that these issues are affecting your students, and that the OCR guidance equally applies to K-12 institutions, and that you all need to be taking a look at your procedures, at naming a Title IX coordinator. So I'll share a few of those statistics. In 2012, CDC reported that 42% of sexual assault victims reported being assaulted before the age of 18. CDC also reported that 4% of high school males and 10% of high school females report that they've been forced to have sexual intercourse against their will. Again, OCR has issued quite a bit of guidance in this realm. The 2011 Dear Colleague letter, of course, has been very notable. But there's also the 2014 question and answer guidance, a long document of frequently asked questions, and then the 2015 Dear Colleague letter that talks specifically about hiring Title IX coordinators. There's a particularly, it's a horrible story, a terrible example of things gone wrong at a middle school in Alabama. There was a 14-year-old girl who reported to a teacher's aide in the school there that she was being harassed by a student. He was asking her to engage in sexual intercourse in the bathroom repeatedly. The teacher's aide, as the story has been reported, is reported in the Washington Post and other sources. The teacher's aide encouraged the student to lure the boy into the bathroom so that school administrators could catch him in the act and then punish him. Unfortunately, administrators were not there in time, and she was assaulted by the boy in the bathroom with no intervention. Just a horrific story. And again, it's easy, I think, to say, well, that would never happen in our district. People wouldn't exercise that kind of judgment in our district. But how do you know? And that's really what the OCR guidance is about, is putting in a systematic approach to ensure that stories like that don't happen. So again, I think if you're looking at that guidance in whole, I think if I could summarize it in kind of three main parts that you want to make sure that you've checked off as far as your district goes. You want to make sure that you've designated a Title IX coordinator. And I think not just designating them as a Title IX coordinator, I think really providing them the ability and background to do that, to fulfill that function well. Again, a lot of these are unfunded. There's not additional funding out there to receive training, but as much as you can provide that person with the background they need to do the job that they're being asked to do, I think that's very, very important. Number two is to educate responsible employees, those employees that are going to have contact with students who are going to be told these stories. So in the prior example would be that student aide that the student came and reported to. And so if they're properly educated, then they elevate the issues to the Title IX coordinator and then use your processes appropriately. Third is, again, put procedures in place to promptly and equitably investigate and respond to allegations. The Title IX coordinator is going to have a huge impact in that role. And that's really the part that's easy to say and hard to do. The investigation of these matters is very, very difficult. Adjudication of the matters is very difficult, I believe. But again, providing those people with proper training, I think, is a starting point. Making sure you have a system in place of reporting and handling and responding to these issues is certainly step one. And as we talked about other issues of bullying and harassment, I think you want to think about how does the Title IX reporting structure fit with kind of your other structures of reporting other types of issues of bullying, harassment that might be based on race and disability, not just gender. And so those are some other things to think about.
Yeah, I'd just like to say a couple things about the guidance from the federal government, whether it's OCR or the Department of Education. I just looked since 2000 and printed just the titles of the letters, Dear Colleague letters, and it was over 2.5 pages long. So we had a lot of guidance, and I urge you to take it seriously unless and until they be challenged and found that the administrative agencies overstepped their bounds. But it was interesting in looking at these, many of them have to do with harassment based on disability. And I know we'll come back to this later, but a lot because that group of students is disproportionately harassed, so we have a lot to deal with that. I also noticed since 2015, they're emphasizing that the harassment on race, or sex, or disability, or religion, on actual or perceived. So you don't have to really have that characteristic. If you're perceived as having that characteristic, it would be considered unlawful discrimination. And I just have to say a little bit about the most recent one, even though we spent a lot of time in the first panel on this. It's amazing to me how much legal activity we're having over a student population that's a minuscule part of our total student population. I think for transgender students, the last figure I saw was like 0.3 of 1%. I mean, it's just really a small number. And if we, in the beginning, had just treated these students according to their ability, none of this would have happened. But now we have 11 states charging that the federal government has overstepped its boundaries, that this should be a local and state issue with the guidance. That litigation could affect other guidance coming out from the federal government because we have so much legal activity. You can look look at NSBA legal clips, the last several issues mainly are dealing with issues of transgender students. So it's very interesting how such a small student population, and again, because of how we responded to that, just I'll go ahead and so much we want to.
I think, Suzanne, you had made reference to even issues regarding sexual misconduct. And I will share with you that that's certainly an issue that was on the minds of the members of our General Assembly this past session. We had amendments to existing statutes designed to protect students from sexual misconduct. And unfortunately, sexual misconduct that's generally was committed by a teacher or an adult upon a student. So we now have provisions that prohibit confidentiality agreements. If we do have a situation where we've investigated an employee and we reach a nice little settlement agreement and then walk away quietly, the General Assembly has now stepped in and said those agreements are now void. That's just the public policy of the state of Indiana is going to be that we aren't going to have confidentiality agreements when the situation involves sexual misconduct. I'm sure you have read in the newspaper the stories about teachers and their licenses, and are their licenses being revoked, and certainly the Department of Education has been, I think, inundated with questions about their policies and procedures, but teacher licensing and revoking licenses based on teacher misconduct has certainly been in the spotlight. And lastly, just a reminder, and again, I think the first panel talked about it, there's certainly heightened awareness on everyone's part as to individual employees' responsibility to report any time that a student is a victim of abuse, whether it's at the hands of a parent or a fellow employee. And if you're the administrator that gets that question, that gets that report, I know it's very difficult because you want to, of course, protect your employee, but you have to think that your responsibility is to protect the student. And clearly we have court cases and the General Assembly saying, as soon as you have reason to believe, you pick up the phone and contact Department of Child Services.
Great. So I know from teaching school law courses at IU, sometimes the students will ask, is there a difference between the legal standards of bullying and harassment and different definitions? One of you.
I'll take a lead on that, but hopefully others will jump in. Technically, there is a difference. Under various civil rights laws, Title IX, Title VI, Section 504, ADA, if you are harassed based on race, sex, religion, disability, that is considered unlawful discrimination and can bring a suit for damages. And that's very important for the victims to think they could get damages from a school district if, in fact, they were harassed. It's a very high bar to be able to do that. It's not impossible, but you have to show that if it's peer harassment, that there was actual knowledge by school personnel, they were deliberately indifferent, that the harassment was so severe and persistent that it deprived the individual of educational benefits. So it's a high bar, but not impossible. In the Davis case, they showed that it could be satisfied. Usually, by the way, the claim is that there's a hostile environment that's created for the victim. That's what creates the discrimination. In the employment context, we have quid pro quo, but usually the peers aren't in a power relationship, so that would be something that would be asserted. We don't have a federal law in bullying. But what muddies the water is that all of the state laws that deal, and we do have state laws dealing with bullying, they commingle the terms in defining what bullying is. And Indiana is a good example. It uses the term harassment in defining what bullying is. Even some of these Dear Colleague letters commingle the terms harassment, bullying. So I can tell you, if I were a call it harassment, not bullying, if I were trying to sue the school district, because I'd be trying to sue for damages, and the school personnel would be hoping that you wouldn't, that you call it bullying instead. So even though technically there's a difference from the federal level, and the federal laws provide these remedies for victims that aren't provided for bullying victims, I think in practicality, we really are using the term the same. For sure, the responsibilities placed on school personnel are very, much the same, whether we call it bullying or harassment. And the bottom line is that I think school personnel have a responsibility to curb and respond, whatever we're going to call this. I will just mention one other thing. There's a very remote possibility that victims could get damages by alleging a constitutional violation, substantive due process rights. No court has bought the argument yet, but the argument continues to be made. We just had a First Circuit decision where that argument was made, but again, rejected. And what that requires is that the bullying or harassment would shock the conscience, and that there is, again, deliberate indifference. And in the recent First Circuit case from Massachusetts, this student who allegedly had been bullied by pantsing. This is the first time I've heard that word. I just hadn't heard the word. But anyway, that was one of the things. And it wasn't enough that it shocked the conscience. I had to show that there was that the school authorities were so indifferent that it caused the deprivation by their indifference, and so it rejected the claim. So I don't think that's going to be a very viable grounds. But the other point,
I'll just add on to what Martha said. I certainly agree the difference between bullying and harassment. I think even as an attorney, I have to look at the definitions quite closely. Working with school administrators, I think maybe one of the common questions is, our bullying laws refer to repeated acts of name calling or offensive behavior. And so, I think sometimes when we focus on bullying, we look at, well, are there repeated acts? There are times where I think a one-time incident can probably constitute harassment, but is likely to not constitute bullying because of the reference to harassment. But on the other hand, when we get into what do the courts look at, certainly they will look at how did school officials respond to each and every incident. So it almost seems to suggest whether this is a first-time incident or a repeated incident. Certainly you are smart for liability reasons to look into it and attempt to do something. Unfortunately, I think we have parents who think any time something negative is said about their child, that that's bullying, and they're aware of Indiana's bullying law, and therefore they want the situation investigated and they want a report made to the Department of Education. And so that's where sometimes maybe the school official has to step in and understand the definition of bullying under our statute and say, I will look into this, but I'm not quite sure at this point whether or not this is bullying.
So I have a question about, you referenced Indiana's anti-bullying law, and this passed in 2013. So could one of you kind of give us an update on the amendments to that law?
Sure, Suzanne. And as Suzanne said, there were amendments to an existing anti-bullying law, and it really adds to this kind of patchwork that Martha described. So there are a variety of laws at the federal and state level, and there are even some local ordinances mentioned in the last panel that might give rights to students or create obligations on the school. And it really is important to kind of consider all of those, and it creates a challenging consistent, I think, if you're thinking about, okay, what do we do as a school if we're going to receive and respond to incidents or complaints? There are all these different laws or legal frameworks that might be applicable, but do we have kind of one cohesive system, or how do we tackle that? I think those are some good questions to be asking, and also be asking in reference to the specific Indiana law. So in 2013, there were some significant amendments. I'll just highlight a couple of elements, but it really puts some procedures in place for reporting, investigating, and responding to incidents of bullying. Interestingly, the statute talks about having disciplinary procedures for teachers who do not report or fail to report bullying that they're witness to. I think one interesting part of the law, the statute references that programs really should be research-based. And so I think that's an interesting part of the law, or having a legal standard that programs should be research-based, and so really there's an ongoing obligation to kind of maintain up-to-date research and be implementing what we're learning into your anti-bullying program. Another very important facet that was talked a lot about in 2013 when the law was passed is that it specifically extended the jurisdiction of schools to be looking into incidents that maybe happened not at a school event or off school property, so long as the discipline really kind of ties back to the school program, or there's a reasonable threat to the learning environment, then the school needs to be taking a response to that. The definition of bullying includes, under the statute, any action that places a student in reasonable fear of harm, has a substantially detrimental effect on the student's health, substantially interferes with the student's academic performance, or substantially interferes with the student's ability to participate in school activities. Again, those are a pretty broad definition, and as Lisa mentioned, even if it's the first time an incident is brought to your attention between two particular students, even if that might not be kind of the repeated bullying that we think of typically in our minds, you want to be asking yourselves, what's the right thing to do to intervene as a school to make sure the students are comfortable. And like was emphasized in the last panel, a lot of these laws are put into place to protect students. And again, sometimes we think about it in terms of the obligation it creates for the school, but really, I think the proper mindset is to think about what protection does it provide for the student, and how do we emphasize that as a school to make sure that our students are feeling comfortable and safe, whether or not that's based on a protected characteristic or is just kind of under this more generic term of bullying under the state statute.
I'd just like to add that one thing in Indiana's law is requiring some kind of sessions for students very early in the academic year. In fact, when this law was first passed, I thought, that's too early, by October 15th, because how can you get everything ready? You're trying to get the school year started and all this. Now, however, you have plenty of warning that that's going to be coming in October, so at the end of the school year, start getting things ready. But it really is, and this goes along with what Stephen just said, we're trying to create a safe environment. We don't want to do things that are going to bring about litigation. We'd like to prevent this from happening in the first place. So having these sessions for students early in the year that talk about what's appropriate, what's inappropriate, what are some of the devastating results of some of the expression and other kinds of behaviors, I think can be a very helpful thing. One thing that's been interesting to me in looking at Indiana's law, but laws elsewhere as well, is that this is not to say that it will impose a burden on participating in any kind of religious events or in expressing their protected First Amendment expression. And here's where I really see the rub, and where I feel really sorry for school personnel. You're caught in a crossfire because you have an obligation and you want to prevent bullying. You want to punish those who are bullying other students, but students are going to say, I have personally no right to do so. And very unfortunate that the courts, at least the Supreme Court, has decided not to get into this and give us some clear guidance. I know in the last panel it was said if there's a split among circuits, usually then the court will step in, and that's been traditionally true. Not true with bullying cases. We do have a split among circuits, and the Supreme Court consistently has declined to review them. So I did see the law having a bit of a conflict there where we're talking about First Amendment rights versus obligations to her bullying.
Do we have time for one more
Sure.
answer?
Sure.
I would just say the addition that Stephen referred to, the amendment made in 2013 regarding extending the jurisdiction of the school's authority to off-school property conduct was very significant, because if you're familiar with Indiana's discipline laws, if we have misconduct occurring or conduct occurring off-school corporation property, we can only suspend or expel if that is unlawful and constitutes an interference with school purposes. So when does most bullying occur? On the computer. Via cell phone, when the person's not in front of us, and we feel free to say some really awful things because the person is not sitting there right in front of us. So school officials were having parents come in and say, my child is getting these text messages, or, here's what's being said on the computer. Well, again, we were somewhat limited as far as taking disciplinary action, and I think that frustrated parents. So that was a very significant amendment. But I think, too, we still have that balance of, we're going to have to prove that that's bullying or harassment. Otherwise, it is potentially going to be speech protected by the First Amendment.
Great, thank you. So there has been more and more litigation, it seems, involving specifically students with disabilities who've been harassed in schools. So we've already talked about Title IX as a claim that students often raise in peer harassment cases. What other legal claims, or what are these students alleging in their complaints in addition to Title IX?
I'll start that one. Well, first of all, you need to understand there are several laws that protect students with disabilities. We've got Section 504, which prohibits discrimination on the basis of a disability. We have the Americans with Disabilities Act, which is very similar to 504, prohibits discrimination on the basis of a disability. But we also have the Individuals with Disabilities Education Act, IDEA or IDEA, whatever you'd like to call it, and it's existed in some form since 1975. This is the law that guarantees the disabled student a free, appropriate public education. So it's unlike the civil rights laws that we talked about that OCR enforces. This is a federal law that says we are responsible for providing a free, appropriate public education to a student who has been identified as having a disability. So much of the guidance that we have received, as we've talked about, has been under Title IX or under the discrimination laws. But now the Department of Education is also reminding school officials that bullying and or harassment can be a violation of the IDEA, or it could result in the student being denied their free, appropriate public education. And so what a court would look at in that particular case is maybe, again, was the bullying so severe, so pervasive that it denied the student meaningful benefit in their educational program. And we did have the Second Circuit just in January of this year did rule in favor of parents in a situation where parents have on several occasions contacted school officials about the bullying of their daughter. Classmates were calling her retard. Classmates were tripping her. And the teacher was doing nothing about it. And administration wasn't doing anything about it. Well, it was time to convene the case conference committee meeting, or the IEPT, whatever you like to call it. And again, the parents said, our daughter doesn't want to come to school. She brings dolls with her for support. She's not getting support. And she's missing 16 days of school. This is all because of the bullying. The school official refused to talk to the parents about the bullying, and she said, this is not the appropriate venue. We're here to develop the IEP for your child. So parents sued, long story short. The Second Circuit said the administration's refusal to address the bullying issues denied parents the opportunity to meaningfully participate in the IEP meeting, which that is a procedural violation, but they looked at whether or not the procedural violation actually then resulted in a denial of faith. And in this particular case, it was easy for the court to say she was being denied a free, appropriate public education by the school's refusal to look at the bullying of the child, because it was interfering with her opportunity to receive meaningful educational services from the school corporation.
I'd just like to add that I think other jurisdictions are going to look at this decision, even though it may not have precedent value there, because special education law, I mean, rights of children with disabilities, that's the fastest growing area of school law we have. Again, not that large percentage of students, but it certainly is a very litigated area, and many of the cases deal with what is a faith. And so I think adding this element of the bullying, since again, I said before, it's disproportionately high incident of bullying with that group, I think we're going to see many more FAPE cases dealing with children with disabilities. I would like to just note, on any of these types, whether it's race discrimination, sex discrimination, disability, whatever, you always can bring a tort suit. You always can bring a suit for damages, saying against the perpetrator, but also you could bring a negligence suit, a tort suit against the school authority, saying they were negligent in supervising or whatever. So I just want to add that you always can bring a state tort suit, even if some of these other grounds don't seem to materialize.
Do you see many suits, so, we know we have negligence and IDEA and Title IX. Do you see lawsuits filed under Section 504 or the ADA? Bullying and harassment to some extent?
I would just say I think there are more suits under 504 and ADA as opposed to the negligence.
Gotcha.
Tort.
Okay. So we've had several great comments up here about bullying and harassment as it relates to Title IX and some of the legal and ethical issues and beyond Title IX. Are there any questions from the audience before we ask our next question that focuses more on expression?
As I'm sure you're all aware, many lower courts are now beginning to apply the standards from Davis v. Monroe in their harassment cases. Any reactions? I mean, it strikes me as a reasonable standard to apply. Would you suggest that that be revised or put into federal regulation or statute or state law regulation?
Well, I guess I would acknowledge, I think that is the court standard. When a court looks at whether or not we've got discrimination on the basis of a disability, they are looking at whether or not the school had actual knowledge and whether or not they were deliberately indifferent to the situation. So I guess what I see from the guidance of OCR, I think they're a little broader. And OCR is, well, it's harassment if you knew or should have known. And OCR also does, it talks not necessarily about being deliberately indifferent. They look at, well, did you do enough? They haven't come so far as to say you have to stop the harassment. But did you do something? And what you did, was it reasonable? Whereas the court's going to say you were deliberately indifferent. You know, the woman who said, I'm not going to talk about bullying at the case conference committee, that's deliberately indifferent. So I see OCR suggesting that it's a broader standard than what the courts do.
Yeah, and even though there's a conflict there, I think OCR is saying, we're going to use this standard, a lesser standard. Should you have known about it? It's not the deliberate indifference, just should you have known, in the decision to withhold federal funds. But to get damages, I still think you have to go back to the Davis standard. And actually, Charlie, and many of the civil rights activists were excited when the Davis case came down because they thought the court would say, you don't have any responsibility for peer harassment whatsoever. It's third party. So they were glad, even though it's a stringent standard, I think that they were glad at least the door was left open.
And Kennedy voiced that in his dissent.
Yeah, I think just to reiterate something Lisa said, I think it's a great question to ask, is the difference in distinction between Davis and what OCR says. But it is always important, OCR could come and perform an audit, and really they're going to hold you to the expectations of what they've said in their guidance, and whether or not that can be negotiated, of course, is something that's a question out there for lawyers to work on, probably. But, that distinction is important. But the guidance still is what the guidance is, and I think OCR would probably still hold you to that.
Great. So what do you think? Might some student expression considered unethical be protected expression under the First Amendment?
I'll take a first stab at that one, possibly. For example, we had a case in California where a federal district court upheld a student's expression right to videotape a group of classmates talking about another student, calling her a slut, saying she was spoiled, and then put it on YouTube. Of course, everybody saw it, and this was very disturbing to the student involved. But the court said, well, a general buzz around school, hurt feelings, that's not enough. That doesn't rise to the level of disruption of the school and therefore upheld the student. Now, we'll add that the Fourth Circuit, in a fairly comparable case where they posted online that a classmate had herpes, upheld the school and disciplined the student, even though it was one student, said that one student's interference with that student's program was enough to create the requisite disruption. So we do have a difference of opinion. That's one reason it's such a shame that the Supreme Court has not given us a decision in this regard. But I think there are a number of cases where something we would consider unethical and inappropriate for students to do, they may have a legal right to do so. The Third Circuit upheld the students in the MySpace profiles of their principals, saying they were pedophiles and they were hitting on teachers and all kinds of other things about them, saying they had a free speech right. It was initiated off school grounds. Well, again, I think we would consider that inappropriate for students to do. So I think this is why I keep coming back to the thing of some kinds of sessions in preparation for students, talking about what is inappropriate and what is appropriate, and having some school regulations in this regard that doesn't have to mean that it's going to violate some kind of federal law. Just talk about what would be appropriate for students to do. And I think this is really important. There's some very moving videos that have been developed by parents of students who committed suicide because of bullying. Well, showing some of those in the student assemblies and other things may curtail some of, and some of these videos, by the way, have all kinds of comments by students who were bulliers. So we have no idea how devastating some of their comments were. So I think trying to educate our students, because we're going to have a lot of things that they may have a protected right to say that we think would be inappropriate for them to do so.
Yeah, and I'm glad Mark mentioned that. I think sometimes there might be a protected right, but it doesn't mean that there's still not room for educational programming. That's what we do. That's what we do best, is educate students. And so there might be some room for that, even if there's not room for disciplinary action.
I agree, going beyond these legal issues to doing what is morally or ethically correct in schools. Good point. Just continuing on about expression rights, what are some of the major Supreme Court decisions governing student expression rights that are pertinent to these claims of bullying?
certainly the major one, Tinker versus DeWine, the Black Arm Man case in '69, and what the Supreme Court said for the first time was that students don't shed their expression rights at the schoolhouse door. Actually, the court said gate, I'm not sure exactly why, but said unless, that you can't curtail their expression unless there's, you can forecast the material or substantial disruption of the educational process or it interferes with the rights of others. This is morphed over time pretty much into the disruption standard. But I think with bullying, really the interfering with the rights of others may come into play more. We've had a couple of courts that have relied on that, but most courts have used the disruption standard. The second case that I think would have some bearing is the Frazier case, and that was the case where the student used in the school assembly a metaphor that was a sexually oriented metaphor, and the Supreme Court said lewd or vulgar student expression can be curtailed. Now, I've never been a fan of the Frazier decision because I've always been kind of an advocate for student expression rights, but I do think it added a new category, the lewd and vulgar, that wouldn't be a category. I mean, lewd and vulgar expression would be protected for adults. It's interesting, I found myself in strange territory because I'm really on the side of the victims in the bullying cases, whereas always before I've been a real free speech advocate. But my feeling on Frazier, a lot of the courts have said, oh, it has to be on campus for Frazier to apply the lewd and vulgar. My feeling is that this is off campus on this computer, and with a click, one click, everybody in the school has access to that. That should be considered school expression. I agree with NSBA that saying the opposite is just a distinction without a difference. I think it's where that grenade lands, not where you threw it from. And it's clearly the digital harassment and bullying is landing in the school. If we consider that school expression, then Frazier would apply. But right now, a lot of the courts are saying Frazier does not apply. I don't think the other two cases really are pertinent to the bullying as much. The Hazelwood, which was the school-sponsored expression, most aren't saying that student bullying is school-sponsored, or the Moore's case dealing with illegal activity. Again, those we don't see as much as we do primarily Tinker, but in fact, the bullying and harassment cases we like in Tinker, but also Frazier to a lesser extent.
I'll just say, I mean, I think when you apply those four major cases, I think in dealing with some of the bullying and harassment issues, I think you start to put some square pegs in round holes and whatnot. I think they're hard to apply those cases exactly. I think courts have struggled to do that. That's why I think Martha was hoping that maybe a Supreme Court opinion on these issues would help clarify. I don't know if that's coming anytime soon. And so I think we'll continue these exercises of square pegs and round holes. But I think the Tinker disruption standard, as Martha said, I think is going to continue to be the key.
And really, it's not a Supreme Court case, then again, it doesn't really answer the question with regard to bullying harassment. There was a case out of the Fifth Circuit that went up to the Supreme Court. We were hoping that they would accept it because it does deal with, again, just how far is the school's jurisdiction? Because this was another videotape created off school corporation property. It was directed more toward an employee than to a student, but again, was highly offensive. Made, very unsettling allegations about the teacher in the school corporation. The Supreme Court didn't accept that.
So what responsibilities do state anti-bullying laws place on school leaders? And do these obligations, do they ever conflict with students' First Amendment rights?
Yeah, absolutely. Now, every state has either policy or law dealing with bullying and placing responsibilities, namely to try to prevent it on school personnel and to report incidences. And if I have any advice to school personnel, it's just document and document more. Because if you document the activities and report them, that's going to be the best safeguard that you have. And again, we have this rub with First Amendment rights and the responsibilities being placed on school personnel. And I really do feel like you're in some ways caught in the middle. And the Supreme Court has been very consistent, as Lisa said, in not hearing the bullying cases. It refused to hear 4 in 2011 alone. And Third Circuit has been the most definitive in saying if it's off campus, initiated off campus, you've got to show that link to a disruption to do any kind of disciplinary action for student comments, even though perhaps quite hurtful. The Fourth Circuit has been more responsive to disciplining the students, saying that if it is hurting another student, that is the necessary link to a disruption. Second Circuit, again, because some comments were made about administrators, again, let the school discipline the students, so took more of a position in favor of the school administration. Our circuit here, the 7th, has not dealt with it, but it probably will at some time. So, my position, as I said before, is that if it originates off school grounds and it impacts the school, we should be able to curtail that. We should be able to discipline the students. The only consolation for school personnel, if you do discipline students for their expression that was initiated off campus, or you just think this was hurtful expression and it's the right thing to do, you probably could not be sued for damages because it's not clearly established law. In fact, it's anything but clearly established law. So I would just urge you to do what you think is reasonable and right as far as curtailing behavior.
Well, and I think that's why the standard really is severe, pervasive, and offensive. I do think there is a recognition that, students are going to say mean things about each other. Or, the question is, does it get back to that student? And that's where, social media is resulting in that. I might, when I was in high school, I didn't even, cell phones didn't exist. So, pick up the phone, call my best friend, and we might talk about one of our classmates and how stupid she is, or never did that. Anyway, that is my right to say that. But I think the issue for the courts and for school officials is, yeah, you might have that right, but when it is so severe, so pervasive, so offensive, that it's affecting what's going on at school and interfering with a student's opportunity to come to school, that's where I think you lose your First Amendment argument.
Great.
So despite all these new legal developments that highlight the need for districts to respond appropriately to various incidents of bullying and harassment situations, aren't there still some due process considerations to keep in mind with respect to these students who are accused of engaging in the bullying and harassment?
Yes. So, particularly when you're dealing with situations that might be attracting a lot of attention, it's easy for cases to become an interest story for media, especially in cases of sexual misconduct. They might involve students or they might involve teachers, as you noted already. And so there might be kind of building pressure to take quick action on your district. And so there are certainly some out there that have argued that the pendulum has swung too far, and that people are engaging in these kind of knee-jerk reactions and not really thoroughly looking into the investigation, thoroughly looking into the matter before taking action. And so keeping those due process rights of the accused in mind is, of course, always as important as taking any allegation seriously, looking into it, getting something out of it. And so I'll talk a little bit from the college and university perspective. As colleges and universities are certainly seeing a huge increase in Title IX litigation, related litigation in cases of sexual misconduct that are being adjudicated through the college and university disciplinary process. And really on both sides, but particularly respondents suing the college and university after being found responsible and alleging due process violations, also alleging reverse Title IX claims, saying that really the system, the disciplinary system that is set up is biased against, and particularly a lot of these claims have been against male, been brought by male respondents who are saying the system is set up really to find us responsible and inherently is biased against us, and that's a gender discrimination claim against me. And so we're seeing a lot of those cases, and a lot of them, unfortunately, right now are on motions to dismiss. And so a lot of the facts that are being pled are taken as pled. But I think you're seeing judges more willing to scrutinize decisions of administrators in those cases, which I think is interesting to know and interesting for this audience to know, because I think that might continue into the K-12 realm. So it's always interesting when you read those cases about disciplinary actions and what administrators have decided to do with respect to students. And oftentimes, this historical case law has been, the judges are very willing to defer to the judgment of administrators because, they know the school and they know the environment best, and I'm sure that view is embraced well in this room. But I think a lot of these new cases, you're seeing people only willing to express that kind of deference when they want to, judges, and really being willing to more closely scrutinize the school's process and scrutinize decisions that are made along the way in ways that I don't think those historical cases have really shown.
I just want to add, I'm really glad, Stephen, the points that you mentioned, and this is a much broader issue than dealing with bullying and harassment. This deals with any kind of disciplinary action in our schools. Fundamental fairness. We need to be fair to all the students involved. And I can tell you, in the years I've been teaching school law, and that's been since the beginning of time, I have never had someone come to me and say, I am being faulted, or I'm being charged, or I'm being sued because I provided due process that wasn't required. Never have I had anybody say that. A lot of times I've had people say, I'm being, sued because I didn't provide due process. So if you're in doubt, give an informal hearing and hear what the student has to say. What are the charges against the student? And give the student a chance to say his or her side of the story. It doesn't cost you anything, and it can cost you a lot if you needed to do so and you don't.
Well, and this is just a good reminder, due process, fundamentally notice and an opportunity to be heard, and also just remember, the greater the deprivation, the greater the due process. So really to just sit down with the student and say, don't do this again. You're not depriving the student of anything when you do that in the school context. And so one might say, there's no due process for that kind of disciplinary action. It's just, again, when we get to the point if we're going to suspend, expel, we're going to remove the perpetrator from the school setting, then obviously greater due process is required.
So it seems like many of these legal issues involving bullying and harassment, some of them at least, could have been avoided with better education of teachers and school leaders. What can school leaders do to better educate their teachers about this area of law who maybe have never had a school law course before, about the law and their ethical obligations?
Well, obviously what's critical to this whole arena is policy and procedures, and making sure everybody knows that policy and procedure. And Stephen made the comment early on, appoint a Title IX coordinator. Well, make sure your teachers know who that is. It's great for administration to say, so-and-so, you're going to be the Title IX coordinator. Well, make sure everyone knows who that person is and what their responsibility is. I think we have to do a better job of getting our teachers to understand when a student calls another student a retard, that's not appropriate. We just have so many instances of where teachers really aren't stepping in and saying, Lisa, I think that's an inappropriate comment to make, and I don't wish for you to make that again. Things like that. I think there has to be an awareness that bullying and harassment can begin with, maybe I'll use the word minor comments that just build over time. time. So policies, procedures, making sure people know, and I think we have to let them know what are examples of bullying, harassment, inappropriate statements.
I agree totally that having sessions with the teachers so they are tuned in to identify bullying before it gets to the point where it has really interfered with a child's educational program. So they really are identifying potential areas that are problematic, but so they'll also have those conversations with their students so that we can perhaps prevent some of the bullying from taking place. And I think also we have not done a sufficient job in looking at the victims and really having some programs, some policies in place that protect these victims. Help them understand this is just a blip in my high school. Don't let it affect your entire high school or perhaps your life, as it has been true in some cases. By the way, our most prescriptive anti-bullying laws all were precipitated by a student suicide. That's what brought about the changes in the laws. So I think we need to focus more on the victims and, again, have these sessions with all of our staff members. And it's not just teachers, it's teacher aides, it's volunteers that spend a lot of time with students. We need to have sessions with all of them. Yes, bus drivers, that's what.
Yeah, I know in Indiana, when our bullying law was passed, and it was mentioned, that teachers could be disciplined for failing to report. I think there were a lot of concerns among any teachers about, oh my gosh, what do I report, what don't I report? That's where I would far prefer that they report to the appropriate official, because really then it's that school administrator who has the responsibility of making that judgment, and of also seeing whether or not there's a pattern. Because a teacher A is hearing something but not reporting it, but teacher B is hearing things and reporting, it's not giving an accurate picture. So that's where I think it's just very, very, very important to have everyone completely understand. And I'll just say, I know this is probably expedient, but I know a lot of school corporations have these, videos that you're required to log on to your computer and listen to the video while you're at home or something like that. I'm just not sure that that's it's an efficient means of informing everyone of their responsibilities, but I'll just say I'm not sure how effective that is. If you're a school administrator who's doing that, I'm sorry. Kill me.
So we've heard some really great feedback and comments from our panelists. Do we have any questions related to these issues of harassment, bullying, and ethics? Jake?
So, as an administrator, there's a certain sense of relief that I feel when all students are off campus and there are no extracurricular activities. There's some peace that I feel. But now with technology integration and the extended learning day and the provision of computing devices to students, the school is now issuing these devices, whether they be Chromebooks or iPads, what have you. And then we're also providing a learning management system where students are interacting and collaborating until the wee hours of the morning. Would that change jurisdiction with a student using a school-issued technology device and on a school-issued form?
I'll repeat the question, and it's a great question. The school corporations issuing iPads, Chromebooks, laptops, a variety of devices to students. Is the standard different for taking action against the student? And the answer to that is yes. If this misconduct, if these inappropriate statements are occurring through school-owned devices, and I do think the bullying law even refers to school-owned devices. Clearly then, I think kind of the First Amendment issues that Martha was talking about go by the wayside, and you have greater authority to step in and take action.
Great. I see hand Ken.
I hope this isn't
of those kids don't have any sense that anything that really terrible is going to happen. And it might be interesting for schools if we knew what the survivors, the bully survivors, what psychological, social, whatever things happen to them. If we could, if it is a very bad experience for the bullies, it might be good to, it might be a way to educate parents before the bully gets out of
And I think it's a great comment about what is the impact on those that are doing the bullying. I don't know of data to report on that, but I think there are studies underway looking at the bullies, and I do know that on some of the material where the parents of suicide victims are telling their stories, they do have some of the bully or the ones that did the bullying, and they're saying exactly what you said. I had no idea that my comments were having this impact on, a classmate, and they're devastated. So I think the impact on the ones doing the bullying is great. And again, these are the kinds of YouTube clips I'd like to show the students so that they start thinking about, if I engage in this kind of behavior, because you're behind a machine, you feel like you're totally anonymous. Nobody is going to, it's very different than if you're looking at someone, you see that tear in their eye, then you might back off. But when you're behind a machine, you don't do that. And so I think having some of those stories told is really an excellent way to hopefully prevent and curb some bullying.
And I can't speak to the research, but I will note that the Indiana law in 2013, when it was changed, did have some references to providing counseling services to the bully in the situation. And so the law, I think, tries to also get at,
TK.
Relative to the conversation about bullying, which I, by the way, thoroughly enjoyed, it appeared as though what I heard was that school districts could be responsible relative to bullying, or better said, cyberbullying of students. I thought I heard that it was indicated. And I'm wondering whether that's true, because if you go back to Tinker, what Tinker says, if I got it right, is a student's free expression rights may be overcome if there's a substantial disruption to the school or interference with the rights of other students. So my question is, what cases have you read where a court has come down on protecting that second part, that second clause? In other words, interfering with the rights of other students. Or has it only been, or has it been limited to disruption of the school?
A great question, and if some of you didn't hear it, his question had to do with, do we have some cases that really relied on that second prong of Tinker, interfering with the rights of others, or have most of them, which most of them have, just relied on the disruption standard? First of all, this is where we see the rub with these state laws that do place an obligation on school personnel to curb digital, electronic, internet harassment and bullying, whereas the students are saying that's initiated off school grounds, I have a First Amendment right. The Fourth Circuit kind of linked the two, TK, said this one student's education was interfered with because they put this on the internet that Shay has herpes, and that interfered with her educational program that created the necessary disruption to trigger a Tinker. But the Ninth Circuit, now this wasn't a bullying case, in wearing the T-shirts with homosexuality is sinful, said that interfered with the rights of others. Those that, have a different sexual preference, that interfered with their rights, said it's an independent standard from the disruption standard. So that took the strongest stand. And in a couple of cases, actually in the bullying case, the Ninth Circuit also said that interfering with the rights of others. So I don't know. Will we see other courts go that route? You know, we have a long time since '69, the Tinker case, where it's morphed into this disruption standard. So I think it's going to take a while for us to embrace the other. If you go back to Tinker, it didn't say one is subservient to the other. It said these two standards. So I don't see why we couldn't have other courts that will rely on that. And the bullying is the prime example to do so.
I think we have time for one more question, right here.
Thank you. I heard the conversation around Suzanne's last question, and even the due process discussion before that, as a conversation about leadership or leader development. I'm curious to have your thoughts on whether there are good or whether there need to be better leader development programs within these schools. That is, you're talking about developing teachers and administrators to have a best practice type of leader approach to addressing issues separated from what may be an inadequate legal standard. I think that's a positive thing. Are schools doing the right things here, or could they do more? And is anyone familiar with legal cases where judges have looked to the presence or absence of those types of programs as an indicator of whether the school district has done the right thing?
I would have to say I don't know that I am aware of a particular program or a best practices type training scenario. I guess certainly I think administrators in school law classes that they're taking when they become administrators are becoming they are aware of the legal standards, but of course I'm sure the time is really insufficient to delve into specific training, specific programs.
Yeah, it's a great question, and I think we have had some cases, not on this particular point, where they've said failure to train is an issue and could create liability on the part of a school corporation. So I think it's a great question, and I would hope that our school law courses are indeed covering these topics and preparing our school leaders to deal with these issues. That's a great question.
Okay, so let's hear it for our panel. These three individuals involved at the Institute. We hope they come back in the future. Just a couple quick announcements. So lunch is on your own. If you were one of the panelists, you should meet in room 3017 at the school event, and I can take you over there if you don't know where that is. So if you were a speaker, we're going to have a meeting in room 3017. But for the rest of you, lunch is on your own. There's several restaurants within walking distance. Lenny's is a great option. There's a Dragon Express Chinese restaurant. There's a sushi restaurant. There's a few others within walking distance from Wilkie Auditorium. After lunch, we have our keynote address. Michael Gregory is here with us today from Harvard University, and we are really thrilled to have him as our keynote this year. His talk is sponsored by the Poynter Center for the Study of Ethics in American Institutions. After Michael's keynote address, we have another wonderful panel. So I'm just hoping you come back after lunch. So we have another really great panel on the Fourth Amendment, student employee privacy and technology ethics. And then we're doing something new this year based on the feedback from the Institute last summer. You guys wanted more time to engage with speakers on some of the more pressing topics that have emerged in the last 6 months or so. So we waited and we scheduled these wonderful speakers around some of the bigger topics. And so you'll be able to interact. It'll be more informal conversations around tables with our speakers. So from 4:45 to 5:30, we're covering such topics as the transgender access issue, racial disproportionality and discipline, school choice, special education, women in leadership, all sorts of, I think, really interesting topics. So please come back after lunch. And thank you so much for attending the sessions this morning. We look forward to seeing you back.
All right, Tom. Congratulations. Good luck, Stephanie.